Well, look, good morning, everyone. We're just going to make a start. So I'm Colin Findlay. I'm with IBBC. I'm Senior Advisor with IBBC. And this session is put together this morning really to have a look at force majeure as an important part of contractual law. As I'm sure you know, the Ministry of Oil in Iraq invoked force majeure clauses in their contracts with the international oil operators earlier this year. But force majeure cascades all the way down through the supply network, and it's important that people understand what it means, what consequences might come from force majeure, and of course what companies can do to help themselves to prepare for force majeure, but also to prepare for the consequences after the fact of force majeure, and to look at some mitigation. So we've invited Quinn Emanuel, who are one of our IBBC members, a legal firm, international firm based across 4 continents, 33 offices and 1,300 attorneys. And I'm delighted to have Melissa Kuhner, who's an international disputes lawyer representing foreign sovereign states, multinational corporations, and is a leading practitioner in international arbitration from Quinn Emanuel, but also her colleague Yassine Gilani, who's also a partner at Quinn Emanuel, and he's focused very much on high-value commercial disputes. So 2 very solid experts who will talk us through this. What we'll do is we'll allow Melissa and Yassine to present their thoughts and knowledge on force majeure, and then we'll take some questions after that. So please sit in, and at this point, Melissa, I'll say good morning to you. Thank you very much for taking the time to join us and to give us your expertise, and I'll hand over to you to take the group through force majeure. Thank you.
Thank you, Colin, and thank you for the invitation. It's obviously a very important topic these days, force majeure, and there's been plenty of events, certainly since COVID, even if you just look in the last 5 years, most recently with the situation in Hormuz, that companies are regularly faced with force majeure events. Now, what is force majeure? Force majeure refers to a contractual mechanism, and we'll speak about it mainly under English law. English law, which I think, as most of the attendees will know, is often the law that governs agreements, even in the Middle East, even in Iraq. I've been myself involved in many disputes, really nearly 15, which are governed by English law in Iraq only. So this is why we're looking at English law, but we do advise under different other laws. And I think one of the events we were thinking of doing with Colin would be looking at this type of situation, but under Iraqi law, for example. But we'll come on to that. But it's important that everybody understands this is English law. Now, force majeure refers to a contractual mechanism that may excuse or suspend performance where there's an event beyond a party's control, which prevents, delays, hinders, or materially affects the performance of a specific obligation. That means that, as you see the summary in the first bullet point here, it's essentially a clause of the contract which allows one of the parties or both parties to excuse or suspend the performance of their obligations. The term force majeure under English law has got no firmly established meaning. That's very important to know. because it means that if there's no force majeure clause in your contract, then there will not be a force majeure mechanism available to you, right? So that's why it's important to have it in your contract. Clauses often define force majeure events as those beyond the party's control. And often they provide an illustrative list of examples, meaning, and I think we've got an issue with the slides, so I'll wait for the slides to come back, otherwise you'll be distracted. Yes, so I think everyone here probably has come across this principle, but essentially we'll go into in more detail what it means, but in all cases, force majeure is an event that is totally beyond the party's control. Now, the other important point is that it's not a freestanding doctrine. So the scope of it, the thresholds, the notice requirements, and the consequences depend on the wording of the contract and whether the party relying on the clause can prove that the contractual requirements have been satisfied, which is why if you think you're faced with a force majeure event, the first thing you do is you open your contract and you read your clause, and then you apply the situation that you're in to the particular clause. So what that also means, and I'm still in the introduction, but just so that we're all on the same page, force majeure has to be thought about carefully at the drafting stage. Because if you do not think about it at the drafting stage and you don't think about what events could occur, and of course, you know, it's a vicious circle, because many of you may say, well, how do I know? You know, how do I know that there's going to be a war? How do I know that there's going to be a flood or an illness that spreads like COVID? Well, that's the point. So you have to think about it in a way that's as wide as possible, that both parties can accept. In other words, the parties have to consider as far as possible the types of disruptions that could realistically affect performance in their sector. Geography, supply chain, and they need to ensure that the clause addresses them expressly where appropriate. So in Iraq-related and wider regional contracts, that may include, for example, government decisions, ministry instructions, sanctions, border closures, customs restrictions, site access issues, security issues, banking restrictions. I mean, by the way, these are all things that I've experienced. You know, a pipeline shutting down, for example, a port disruption, a transport route, including a pipeline, being disrupted, or even interruptions to critical supply chains. You know, why am I saying this? Because in some regions and in some sectors, some of these may be relevant and others not, but the wider you think about it, the better, really. So this is where the situation around the Strait of Hormuz becomes a useful example. A contract may not specifically refer to the situation in Hormuz, and at first, the disruption may seem remote from the project site. But if the performance of the contract depends on the move of cargo, for example, fuel, equipment, spare parts, chemicals, construction materials, and other project critical goods through the Gulf, then disruption around a maritime choke point may directly affect the ability to perform. And so this is why a well-drafted force majeure clause should not only consider obvious events like war or terrorism or government orders. You know, most people, if you ask them what's force majeure, that's what they'll say. But the clause also has to address practical routes through which the performance may be affected. So the practical question is not simply whether disruption is possible. Everybody knows, you know, disruption can occur in a contract. But the real question is whether the contract, the internal decision-making, and the evidential record will be strong enough when the disruption occurs. And this is where the particular setup of the force majeure clause is important. And so one topic, which is of course very dear to Colin's heart, is this is particularly important for businesses further down the contractual chain, right? So not necessarily for the big contractors who've got the concession, for example, but further down the chain for any contractor, subcontractor, logistics provider, local suppliers, maintenance companies, service providers, security contractors, any downstream operator, for example. A major international operator may have group resources or alternative supply chains, for example. They'll have political risk advisors, but a smaller or a mid-sized business may not. And that's something to take into account. So for that business, the disruption may quickly become a real cash flow issue, an employment retention issue, and ultimately a survival issue, because the company may not just survive the issue. So this is why force majeure should not be treated simply as a legal defense, but it should be understood as part of contractual management and business continuity for all companies. I mean, this applies to big or large companies, but it's something that needs to be focused on at the stage, of course, where you sign the agreement. Now, let me start perhaps with a specific example. So assume that the Iraqi Minister of Oil issues a decision that effectively shuts down a facility, operating site, pipeline route, export route, or a key part of the supply chain. That's by decision of the Ministry of Oil. Now, in any kind of energy, infrastructure, logistics downstream operation, that kind of decision from the Ministry of Oil can have immediate consequences. It may stop access on site. It may restrict exports. That's happened to me so many times in Iraq. It may interrupt deliveries. It may affect payment flows, and it will, of course, prevent performance. And it will, for a continued period, affect commercial operation. Now, the first question every board is going to ask is what happens to this contract? The board will go to a general counsel or to anyone really who's managing the contract. Sometimes it's the CFO because there's no general counsel. And the board will say, is performance suspended? Can we suspend performance? Can either parties terminate? Do we still have to perform? Do we still have to pay? Can liquidated damages, for example, accrue? Can a performance bond or a guarantee be called? Can we reduce staff? Can we recover costs, or can we restart if the disruption ends? These are all questions that even today I'm having to answer on multiple disputes. Under English law, the answer is rarely found in the words force majeure alone. So you can't just go to the law, open a bunch of questions. It depends on the specific wording, right? So one key point perhaps to remember for everyone, and then we'll go into more detail, is that force majeure does not usually make the contract void from the beginning. Very important. More often, but of course you need to look at the contract. More often what happens is that if the clause is properly engaged, and we'll look at it in a minute, whether it's engaged or not, what happens is that it suspends the affected obligations, it extends the time to perform them, and it excuses certain consequences such as delay damages, for example. And it may allow termination only if the event of force majeure continues for a defined period. So don't think that suddenly the contract is off because there's an event of force majeure. That's not the case. This is what I mean when I say the contract is not void from the beginning. So the reason why this distinction is very important is that if a party wrongly treats the contract as having ended when it's only suspended, the party may create its own default, and that in itself is an issue. Conversely, if a party refuses to recognize a valid suspension, and terminates for delay, then that termination may itself become wrongful. Now, you may say to me, well, this all sounds a bit complicated. Maybe we should speak to lawyers about this. Possibly, yes. I mean, this is why we advise on so many. And it takes time. And sometimes there's several of us who are interpreting the clause and thinking about how to advise the client. So it's not straightforward, but you need to think about it in the context first of the contract. Now, force majeure, perhaps let's see the next slide. Yeah, so once the immediate operational impact is understood, you understand, well, in what way has this event affected us? What do we need to stop? What's happening? The next question is whether the event is truly force majeure under the contract, or is it simply hard luck? Right, this is obviously critical. So if a facility, let me give you an example. If a facility is closed by government order, or if an export route is blocked due to security restrictions, for example, or if a performance becomes legally or physically impossible, think about the fact that it can't be due to either parties and it needs to be an external force, right? So imagine an export route blocked, the pipeline is shut. The pipeline's shut. You can't send any goods because the pipeline is shut. Then the force majeure argument may be very strong. Now, if, on the other hand, the performance is still possible, but it's just more expensive, let's say the logistics costs have doubled, or the insurance cost has doubled, like in the Hormuz situation, or the project is just less profitable, for example, the business is losing money, say, then that may not be automatically force majeure. It may be something called hardship, right? What we've put there is hard luck. If the contract contains such a clause, it may be change in law if the contract contains a change in law mechanism. It may be a tariff adjustment issue, for example, or an insurance issue, or even a political risk issue, but it's not necessarily force majeure. And English law, and that's the same under many laws actually, does not generally relieve a party from a bad bargain, merely because performance has become more difficult, more onerous, and less profitable. So if the contract contains no applicable force majeure clause, no hardship, no change in law, then the remaining common law doctrine, and this is where it gets a little bit technical, and you should probably go see a lawyer at that point, definitely, that's frustration. So, but frustration is very narrow, and it requires a supervening event that makes performance impossible, illegal, or radically different. So it's not usually enough that performance has become more expensive or commercially unattractive. I mean, the bottom line is, if you're just not making as much money as before, the likelihood is it's not force majeure because you're not being prevented from actually performing under the contract. So this is also why the Strait of Hormuz example needs a very careful analysis. A disruption around a maritime choke point, for example, may be serious, right? But its legal effect will depend on the specific obligation affected. So if a named shipment, for example, can't move, if a carrier suspends service, or if a port access is restricted, the analysis may be different from a case where the only consequence is a general increase in cost. So losing money is not usually enough. Reduced profitability is not usually enough, and increased cost is not usually enough. So again, the starting point will be the contract, and the threshold language in the clause will matter. For example, a clause that applies only where performance is prevented is narrower than a clause that applies where performance is hindered. So even particular words such as, are you prevented from doing it, or are you hindered? Are you delayed? Are you materially affected? All of these are different standards. And those works will strongly influence the analysis. Now, let's just have a look at the different stages of a force majeure event now. Okay, so stage one here you can see is triage. What's triage? Well, the business must understand what happened, which contract is affected, which obligation is affected, which performance is delayed, hindered, all the words we were looking at before, or made more expensive simply. Stage two is preservation of rights. So that means that you send an initial notice. Let's say that collectively as a team, you've decided, okay, well, this is actually an event of force majeure, it's not something else. Then you send an initial notice, you reserve your rights, you check insurance notifications, you protect privilege where it's appropriate, and then you avoid statements that later undermine the force majeure position, right? So you're careful to what you say, basically. Stage three is the operational response. So the company has to test alternatives, and we'll see why legally that's really important. You need to decide what can still be performed, identify what must be suspended, and put mitigation or reasonable endeavor steps in place. We'll go into mitigation in a minute. That's really critical. So, but just in practical terms from now, this is where operations, commercial management, finance, legal, everybody has to work together to see, look, what can we still do and what can we definitely not do? Stage four is the management of the contractual chain. So the company should align itself and its position under the main contract with its position under subcontracts, supply management, logistics contracts, right? So that's the knock-on domino effect that force majeure has. It's not enough to just send a force majeure notice upstream while ignoring notices received from subcontractors downstream. So let's say you're the company that holds the concession, the pipeline is shut, you notices are sent at that level, but then there'll be other notices that your suppliers will be sending to you, and you need to deal with those as well. Stage five, which may be very quick to come, it may be the force majeure event only lasts a week or 2 weeks or 3 weeks, right? Or it takes years. I've had one contract has been in force majeure for 3 years. So that's why we call it the exit or the restart stage. So if the event ends, the company must be ready to restart, remobilize, update schedules, deal with accumulated costs, right? Whereas if the event continues, like I said, for 3 years, then the company has to consider whether that suspension is so long that it triggers termination rights. And this is what we've done in a number of contracts where we terminated, and then there was the termination triggered a number of different clauses, in particular, payback clauses, for example. Let's say, for example, one party has given to the other party a certain amount of cash for certain things to be done. And this can be in hundreds of millions or billions. And the event of force majeure occurs. The party who's given the money says, okay, well, I'm going to terminate now. And there will be many consequences under the contract that are triggered by that termination. So the same discipline applies to the notice. Let's have a quick look at the notice. Now, many force majeure claims fail, not because the event was not important, but because the party that was affected didn't follow the contract when you notified. So notice requirements can be very strict. A contract may require notice within 24 hours, 48 hours, 7 days, or a certain defined period, so you must pay attention to that. It may require the notice to identify the event, the obligations affected, the estimated duration, for example, or the expected impact. And it may say, well, you need to identify mitigation steps, meaning what is it that you're going to do in that period? Are you just going to sit around, or are you going to actually try to mitigate? That means reduce your loss. It may also require periodic updates, so you need to be careful with that. So in some contracts, very important, notice is not merely administrative, it'll be a condition precedent or a precondition to relief. So if you haven't done it, then consider yourself unprotected. So let's say the notice is late, for example, or it's defective. It may weaken the claim you have. It may completely defeat it, even where the underlying event was completely real, which is why you have to pay a lot of attention to it. So the practical solution for companies is that internally you need to have an escalation process. If an event affects delivery very quickly, very, very quickly within the company, there needs to be, and by event, I mean, like, let's say, for example, the site access is restricted, or the customs clearance, there are problems with that, or, payment, logistics, like someone has to check the contract quickly. Because if you need to say within 24 hours and you say it 3 weeks later, well, that's not going to be very easy to argue later on. For example, let me give you another Hormuz-related example. The notice should not simply say, regional instability has affected our business. It should be more precise. It should identify the affected shipment or the obligation, the vessel, the carrier, the port, the expected delay, the immediate alternatives, and the documents that are going to follow. Not just, sorry, we can't perform because of what's happening in the Strait of Hormuz. That's far too superficial. Now, the other point to be realistic, of course, is that the first notice doesn't need to prove the entire case. It doesn't need to be totally perfect, but it should be prompt and it should be factual and it should identify the affected obligations. And then a more detailed update can be sent in due course. Now, let's speak about mitigation, because we spoke about it, but initially I want to really pause on it. So after the notice, the next step is mitigation. Now, many executives will think, if we can't operate, we're protected. But a court under English law will usually ask a different question. They will say, well, what did you do to try to operate? What did you do to reduce the impact? What did you do to preserve performance or to limit the loss? You are not just excused because suddenly the pipeline is shut. Now, it may very well be that the pipeline being shut means that you literally cannot do anything, right? But you have to look at alternatives. Maybe there's a different pipeline. Maybe you can truck. Maybe trucking is 2% of the pipeline, so actually it's really not worth doing. But you have to have a process internally where you consider options. In other words, and to put it simply, like in our first bullet point there, force majeure is rarely a do-nothing clause, right? Very important. It doesn't mean you're authorized not to do anything. So most contracts in practice would ask the affected party to use something called reasonable endeavors to avoid or overcome the event or to mitigate its effects. So what does it mean in practice? Some examples: you need to consider alternative suppliers, substitute materials, maybe revise sequencing, partially perform, temporary storage, remote working, different ideas. When a disruption arises around a maritime choke point, such as the Strait of Hormuz, so this may include, for example, checking an alternative vessel is available and whether the cargo can be rerouted through another Gulf port, or whether overland transport, as has been done quite a bit, is feasible for some material, whether critical spares, for example, can be sourced locally, whether non-critical activities can be resequenced. These are all options that the business will consider, and the business with the lawyers as well, I would say, would consider. But, and this is where it has to be, again, clear, reasonable endeavors, as the name indicates, has to be reasonable. It doesn't mean doing the impossible. So those reasonable endeavors don't require a party to take unsafe, That's the third bullet point there. Unsafe routes, unlawful measures, irrational, commercially disproportionate steps. You know, nobody's asking you to do anything that's impossible, but you just have to look at alternatives. So if the only alternative route is unsafe, illegal, technically unsuitable, too slow, for example, to meet the purpose of the contract, it'll take months to get there, or commercially disproportionate, it'll really become way too expensive, then the company should record that analysis. You know, you should have a memo there saying, well, you know what, we tried, but it really is impossible. We tried these routes or we tried these means, but it's impossible for the following reasons. So I would say, for example, a local service provider should not necessarily be judged as if it had the global logistics network or the balance sheet, or in fact, the crisis management infrastructure of a multinational. That makes sense, right? So the question is one of reasonableness, but the practical point is really documentation, as I explained. And in arbitration, which is where sometimes these disputes go, which we do a lot of, it won't be enough to say we try to mitigate. You have to explain how and what you did. I apologize, that's my phone. So then let's move into the next step, which is managing contractors and subcontractors in the contractual chain. So let's put ourselves in a position where a company receives a force majeure notice from its supplier, while at the same time needing to send its own force majeure notice to the employer or to customers. Now, those two positions must be coordinated, as I was saying before. So if the company accepts too much from the subcontractor, it may weaken its position upstream, right? If it rejects every subcontractor notice without analyzing it, it may create a dispute downstream. So you really have to make sure that what you say upstream also is what you accept from your downstream contractors. The business has to map out the contractual claim. That's very important. What does the main contract require? What do the subcontractors say? Are the notice periods aligned? For example, do the clauses cover the same events, right? And this is something you need to be ready. Also, I would say at the stage where you're negotiating contracts, where you're putting contracts in place, make sure that it's the same force majeure clause on either side. For example, there could be one clause that refers to prevention, while another clause in another contract refers to hindrance, right? Are there different termination periods, for example? Are there different cost consequences? So this becomes important in a supply chain example. For example, this happened on one dispute, actually, something very similar. So you have a logistics contractor which relies on a Hormuz-related vessel disruption. A supplier may say that it cannot ship the cargo, right? A construction contractor may say that it cannot complete because the equipment has not arrived. The employer may say that the works should have continued by resequencing. So unless the contractual chain is managed coherently, the same event can produce completely inconsistent positions across the project. So you need to request evidence from contractors quickly, and you need to provide periodic updates. You need to preserve rights under the subcontracts. You need to check whether substitute performance is available, both upstream and downstream. Employees, cash flow and restart capability, that's also important. I don't know whether we've got a different slide on that, Yam, or yes. So, I mean, the human and financial dimension, this is often where the legal clause becomes a business crisis, essentially. So imagine you're a downstream operator and you've got 500 employees. You've got a ministry decision that we were speaking about before, which shuts down the project. Revenue stops. The company still has to pay its payroll and accommodation and security and equipment and suppliers, right? Now, a force majeure clause in the English context may suspend obligations under the contract, but it does not necessarily suspend obligations under employment law. So local labor law obligations may be different, and you have to pay attention to those. You have to look at those. Immigration obligations may be different, tax obligations, social security obligations, mandatory local law. So the board faces a very difficult question. What do we do with our people? So this is not purely a legal question, it's also a business continuity question. So one option, if we just try to imagine what happens, right? Immediate workforce reduction. So that's one option. You can say, well, you know what? I don't know how long the pipeline is going to be shut. I don't know. I mean, it may be a week, but it may be 6 months. And I think it's more likely to be 6 months, or I think it's more likely to be 6 days, right? And depending on how long you think this is going to go on for, you would take different measures. But let's say, for example, that you think it's going to take a while. Then one option is, as I was saying, is immediate workforce reduction. So the advantage of that is that it preserves cash. You know, you're not bleeding cash. But it also creates a risk because you've just made a lot of people redundant. You've just lost a lot of skilled staff. Your reputation may be damaged as an employer. You're unable to restart quickly. You just send them all off and they may end up somewhere else. Another option, which is the complete opposite, is full retention. So you say, you know what, we've got 500 employees, we really need them. Even if it's going to go on for 6 months, we can't afford to lose them, because the day the pipeline, for example, starts again, then we really need all that stuff there. The issue with that, of course, is that even though it means you're operationally ready to start again, you're going to be burning significant cash, and if the shutdown continues for a long time. So often what we see is a staged approach. So the company could identify, for example, a core team for safety, maintenance, people who really need to be there, security, preservation. And then if it has the ability, it may not, but for those who can, they could re-employ the staff on other project. They may second the staff. That means sending the staff to affiliates or counterparties. You may use the time to train as well, for example, the staff. I mean, I've even seen companies who say, well, you know what, we have linguistic issues, on that project. Why don't we, give the staff some English lessons, for example. You could have reduced hours, temporary salary adjustments, say, look, you can stay home and come to the English classes, but we're going to have to cut down your salary a little bit. So you can classify the workforce as well, like who's really essential, who's not, who's needed for restart, who can be re-employed, redeployed, etc., etc. I mean, you can imagine these are very, very, very long. You need to consider very carefully specifically the staff. It's not so much a legal question, but of course it'll be connected with our legal question. I think, Colin, you had a question yourself here actually about that. Or maybe it's a bit, no, sorry, you know what, actually, you know what, let me perhaps, sorry, Colin, let me just quickly go into who pays, because that is a legal question, and then we can go into your question after. So usually, the CFO will say, well, who's going to pay for this, right? Because we're now stopping, who's going to pay? Now, if operations stop for 6 months, who's going to bear the cost of idle staff, the equipment, and everything that needs to be paid, right? Now, many force majeure clauses are not generous on cost. So they may suspend performance or they may excuse delay, but they will say, and you won't like this, but they will say each party bears its own costs. This is the unfortunate situation we're all in, so everyone basically pays their own way. It could seem to be very commercially harsh, but that is the situation. Other contracts provide additional routes. For example, they might give you more time to perform. There might be cost compensation. There might be some sort of variation in construction contracts, mechanisms or tariff adjustments. So sometimes, basically what I'm saying is you need to check, because sometimes the cost consequences can be surprising. And for businesses operating with limited liquidity, the legal question, is it a force majeure event, may turn out to be less urgent than the financial question, which is how long am I going to survive if each party bears its own costs, right? So for someone who's downstream, it may be very important to make sure that force majeure clauses that you have take into account the cost consequences and protect you, frankly. Now, if we go to the next slide, this is about drafting the clause. And the reason why we've put this here is because now that all the concepts have been explained, this shows you, it's like a cheat sheet about what you need to look at and make sure that a good force majeure clause covers, right? So you see triggering events, you need to identify the triggering events. And I could rattle through it, but I don't want to bore you to death. But, make sure that if you think there's going to be border closures, customs restrictions, sanctions, embargoes, infrastructure, make sure that they're all considered. Second, it should specify the impact required. What event actually does the event actually need to prevent performance, or is it simply a delay, for example, or hindrance? Third, it should identify the obligations affected. So does the clause apply only to delivery or completion date, or does it also apply to payment, site access? What obligation is affected? Fourth, it should include a realistic notice procedure. So a complete notice package, for example, within 24 hours, it may not be realistic in a crisis situation, right? And so a better structure would be, for example, an initial notice as soon as possible and practical, and then followed by a more detailed update. Fifth, you need to require evidence. So what is the event that has caused the force majeure? Is it a ministry decision? Is it a government order? Is it something else? What is it? You need the evidence of that. And then the clause should address mitigation and reasonable endeavors, which we've just seen, before going into the consequences. And as you would have understood from the previous slide, the consequence has to be very clear. Does the clause suspend obligation? Does it extend time? Does it suspend liquidated damages? Cost allocation, very, very important. And the final one, perhaps, that I would say here is that the clauses need to be coordinated. The force majeure clause needs to be coordinated with related clauses. So in other words, you shouldn't just look at the force majeure clause. You should look at all the other clauses that I've mentioned, starting with the termination clause, the payment clause, the dispute resolution clause, hardship sanctions. I mean, this is where, of course, a lawyer is helpful to do that job, because you need to make sure it all works together. You wouldn't believe the contracts that don't, where many clauses don't work together. Now, perhaps, yes, would you like, I think, I'll just mention that, often companies will look at model clauses and they'll stick a model clause in a contract, right? That's not the best option, because the model clause, as you would have understood from everything we said today, the model clause often won't address your particular situation. So it's important to look at the model clause, but then you, if you're a GC or with your lawyer, you do a proper job. Yes, so I think we're almost done. Perhaps that's when, Colin, we could do your question. Yeah.
Well, no, I think you've covered a huge amount of ground there, Melis, and it's incredible how complex and challenging force majeure is for a business. And the bottom line, I think, for everyone on the session is that it's business critical, but it can also leave you with very limited arguments if it's not managed well. So I think that the takeaway in many ways is right from the get-go, you have to understand that if you're in a critical sector where force majeure is possible, then you really need to get ahead of it in many ways. But I'm interested in what you say there by who bears the cost. If you know, and particularly when you look at downstream, you know, sort of second and third tier, where, as you say, if people are having to pay off staff or hold staff, is there no real obligation at all on the contract holder to have any consequence for the cost of invoking force majeure, or is it just really a case of everyone has to cover their own position? And because that can be such a challenging circumstance, especially for the smaller companies involved.
I mean, the answer will lie in the contract, and this is where I think the practical step that could be taken for any company really is to look at the contracts and at the force majeure clauses, and based on everything I've said today, to try to imagine, well, you know, how is this going to work in practice? And to the extent that the contract hasn't been signed yet, or there is room for renegotiation, is to make sure that that is in the contract. Because if this cost sharing, you know, for smaller companies, for example, is not written in the contract, of course, the larger company could always say, well, you know what, we're going to keep paying suppliers and subcontractors because we know that we need them, and we've got a bigger balance sheet, and you know we want to be ready to restart in 6 months. But unless the company is obliged to do it, right, the big company is obliged to do it under the contract, or they voluntarily do it even though they're not obliged, you can't force them to do it if the contract itself says everyone bears their own cost in the event of force majeure. Right.
But in many ways, it comes to the operational criticality, I suppose. Then, if as you say,
true.
if on restart, the main contractor needs the people from their subcontractors, they really have to do something as part of their mitigation to say, okay, we need you when it starts up again, so we're going to do something. So anyway, but that's a commercial argument. I think, Melis, where are you with your presentation? It would be good to ask if there are any questions from our audience, or have you got more to do to complete?
I haven't. I mean, I think we've covered it. You see, we've got some practical steps at the end, but they pick up on all the topics that we've laid out. So I don't need, you know, to go through it.
Let's see
if anyone has questions.
Yeah. We're happy to take questions if anyone has any at all for Melis at this stage. I would say that, Melis, if you don't mind, we'd really like to share your presentation with the audience, if that's okay.
Of course, yes.
Which would be very useful. So we will do that after the event. We'll send everyone who's attended or registered to attend a copy of the presentation, which would be very useful. But if anybody's got a question, could you put your hand up, please? Okay.
I mean, I have a question to the audience, and I don't know if anyone wants to answer, but has anyone been faced with applying a force majeure clause? Is that why you attended this session? You know, is it because it had practical relevance to you in your business because it's occurred? Is that why you've all attended? I don't know if I'll get an answer to that question, but let me try.
Yes, thank you very much for your presentation, Melis. This is Morimoto from Mitsubishi Corporation. And this is between us only, but we declared the force majeure for taking the certain oil product from the Iraq. Then my question is of course this kind of situation cannot be controlled, and almost all of the off-taker of the same products declare the force majeure. But my question is when what should I say? It's very complicated and difficult to explained, but the Strait of Hormuz opened, but closed again. Then this kind of situation would continue, I think. Then I'm wondering until when we keep declaring the force majeure, because it is fact that Iran declared the reopening the so-called Strait of Hormuz, and what kind of event would be the trigger for us to lift the force majeure?
You mean when does it end?
Yeah. When does it end, or when we can reasonably lift the force majeure declaration? On what kind of the event?
Masahiro, so you're saying because there's potential for repeat events of opening and closing and opening and closing of the Straits
Yes,
of Hormuz, when is it reasonable for you to think, okay, it's safe enough now for us to lift the force majeure? That's your question?
Yeah, exactly. Yes.
Any thoughts on that, Melis?
Yeah. So what I have seen is that this is part of mitigation, Masahiro, because if, for example, you've declared force majeure, but then there's a period during which you can perform again. And that period is not one day, maybe it's a week or 2 weeks or even a month, right? And so, and it's not difficult to perform, you can actually, it's not impossible, because there may be situations where you have 1 or 2 weeks, but actually you don't have staff anymore because the situation has gone on for so long that you send your staff away, right? But so if there is a period during which you can perform, I would say you partially perform, but you keep the force majeure event still there. You're just mitigating your loss. When it gets to the point where actually the event, the trigger event, let's say it's a war or whatever it is that's triggered the event, actually is lifted completely, then that's when you go back to actually saying, well, you know what, the force majeure is over now. But unless the event is truly gone, I wouldn't stop the force majeure. I mean, it's a delicate balance between deciding whether you're just mitigating, the force majeure goes on and you're mitigating, or you're saying, you know what, the force majeure has stopped, you go back to normal, and then maybe it starts again, and then, for a while there's force majeure. There's one contract, very large contract, construction contract, where there's been a number of force majeure events. So not one continuing event, but several security incidents that have created different force majeure events, 1, 2, 3. And in between, everything was normal. So in that case, it was event starts, event stops, normal. Event starts, event stops, normal. But in the Hormuz situation, the event is ongoing and the affected parties are mitigating by still performing. I don't know whether I've asked your question.
Yeah, understood. Thank you. Yes,
I think it's very much a commercial decision, Masahiro, in some ways. But I think also the effort involved in putting in place force majeure and then also handling it would perhaps suggest that it's probably easier to do it once rather than multiple times. But I think there are so many other complex issues. We're running out of time. We've only got a couple of minutes left. I'd just like to ask if there's any other questions from anyone before we close. Don't see any hands up at all. So, well, look, Melis, I really, really appreciate your time and your expertise on behalf of IBBC. It's really helpful for for everyone in IBBC. These are really practical things. I mean, it's a very challenging time when something like what's happened in the Middle East is created massive contractual risk, and it's been very, very useful to at least get a sense of the scale and a sense of the criticality, but also the sense that you can do things about it. But it's not a passive thing, it's a proactive thing. You have to be proactive with force majeure, otherwise it can be an extremely costly event. It can be costly regardless, but if you don't manage it well, it will be even more so costly. So
that's right.
So for everyone on the session, we will send you some information about Quinn Emanuel and Melis and her work. We will send you a copy of the presentation. And if you have any questions at all that come to your mind once we're closed, then please feel free to put them to us, and we'll make sure that they get to Melis and her team. But I think for now we're just about all out of time. So thank you very much, Melis and your team for
Thank you for having us. It was a pleasure.
Time to do so. Delighted to see everyone online.
Same here.
But we're out of time, so thank you very much indeed to everyone for joining us today. Thank you.
Thank you. Thanks all. Thank you, Colin. Bye-bye.
Thank you.
Goodbye now. Bye-bye.
Bye-bye.